Property management in Arizona involves specialized legal and fiduciary responsibilities under both the Arizona Department of Real Estate, ADRE, and various landlord-tenant statutes. Licensed brokers and salespersons who manage properties must handle funds properly, comply with disclosure laws, and maintain accurate records, unless they fall under one of the limited statutory exemptions. Under ARS, Paragraph 32, 2121A15, there is a license exemption for individuals or entities managing short-term rentals, typically those rented for fewer than 30 days. This exemption applies when an owner or property manager handles the rental directly and does not represent others for compensation. For example, an owner renting out their furnished vacation home on a platform like Airbnb or VRBO does not need a real estate license, as long as they manage only their own property. However, those managing short-term rentals for multiple owners or receiving compensation for third-party management must hold a valid real estate license. Multi-housing and commercial property management may also be subject to limited exemptions. Employees working for the property owner or a management company may not need a real estate license if they perform only routine administrative duties, such as collecting rent or coordinating maintenance, under the owner's supervision and without negotiating leases. However, once an individual performs acts requiring negotiation, advertising, or trust fund management for others, licensure becomes mandatory under ARS Title 32, Chapter 20. The Arizona Residential Landlord and Tenant Act, ARLTA, governs rental housing relationships between landlords and tenants in residential properties. It outlines the rights, responsibilities, and remedies available to both parties, covering topics like rental agreements, security deposits, maintenance obligations, and eviction procedures. Similarly, the Arizona Mobile Home Parks Residential Landlord and Tenant Act provides additional protections specific to mobile home communities. This act addresses unique aspects such as space rentals, long-term leases, park rules, and tenant rights regarding the sale or relocation of their mobile home. Under ARS, Paragraph 33, 1310, the security deposit is defined as any refundable money paid by a tenant to ensure the tenant's performance of the rental agreement. Landlords may not charge a security deposit exceeding 1.5 months' rent, although they may also collect non-refundable fees for cleaning or pets if properly disclosed in writing. The landlord must hold deposits in trust and return refundable portions within 14 business days after termination of tenancy, along with an itemized statement of deductions. Also, under ARS, Perv 33 through 1310, a rental agreement is defined as any written, oral, or implied contract setting forth the terms under which a tenant occupies a dwelling unit. It establishes obligations such as rent payment, property maintenance, and the length of tenancy. A written agreement is always recommended to prevent disputes and ensure compliance with ARLTA. ARS, Paragraph 32-2151, outlines the overview of trust money and deposit requirements for licensees. Brokers handling property management or rental transactions must deposit tenant and owner funds into a trust account separate from personal or business operating accounts. These funds include security deposits, rent, and prepaid expenses. Brokers must keep complete records, reconcile accounts monthly, and disperse funds only as authorized by the owner or tenant. This statute ensures accountability and prevents misuse of client funds. ARS, Paragraph 32, 2174, provides an overview of property management accounts, requiring brokers to maintain a designated trust account specifically for property management purposes. The account must be identified as a trust account, and all funds received in connection with property management, such as rent, deposits, and maintenance reserves, must be promptly deposited. The employing broker is responsible for maintaining accurate ledgers, reconciling the account monthly, and ensuring that all disbursements align with the property owner's instructions. Under ARS, PR 32-2153A, 9, A broker may face disciplinary action for failure to remit payments received in connection with property management or sales transactions. This includes withholding rent proceeds, security deposits, or owner funds beyond the time specified in the management agreement. The statute reinforces the fiduciary duty to handle client funds promptly, honestly, and in accordance with contract terms. Finally, ARS Paragraph 32-2175 covers the record-keeping requirements for property management. Brokers must maintain all property management records for at least 5 years from the termination of the management agreement. These records include trust account ledgers, owner statements, leases, maintenance invoices, and correspondence. Proper record retention supports ADRI audits, owner accountability, and consumer protection. Together, these laws create a comprehensive framework, ensuring that property managers in Arizona act with transparency, competence, and fiduciary integrity while managing the financial and operational aspects of rental properties.